All right. So Riley, you'll be needing to just start welcome people as well. Let's just admit them as well. Welcome, everybody. My name is Father John Pettigo. I'm with Catholic Charities, and welcome to our monthly brown bag conversation on race equity. Our director and producer is Junior Butler, and I will now give it over to Junior Butler.
Good afternoon, and thank you for joining us for this afternoon's program. First, we would like to welcome you all and thank you again. I know I'm repeating myself. However, we'll now have the Black National Anthem by Riley. Thank you, Riley.
Lift every voice and sing. Lift every voice and sing till earth and heaven ring with the harmonies of liberty. Let our rejoicing rise high as the listening skies. Let it resound loud as the rolling sea. Sing a song full of the faith that the dark past has taught us. Sing a song full of the hope that the present has brought us. Facing the rising sun of our new day begun. Let us march on till victory is won. Let us march on till victory is won. Yes. Yeah. Come on.
Thank you. Thank you. We're honored to tell you a little bit about our speaker, our esteemed speaker for today. She is a legal commentator and a police reform advocate. A graduate of Stanford Law School, she became the first African-American woman jurist in Northern California, a position she held from 1982 to 2001. Prior to her time on the bench, she was the first lawyer to open a private practice in East Palo Alto, a low-income community of color, and she was an assistant dean at Stanford Law School. She is an artist and a pianist and resides in California with her partner. She is the proud mother of 2 daughters. Our speaker will provide excerpts from her book entitled Her Honor: Life on the Bench, What Works, What's Broken, and How to Fix It, How to Change It. This beautifully written book is an entertaining and provocative look in the hearts and minds of judges. It shows what it's like to wear judicial robes and to make judgments that determine the course of other people's lives and what it means to everyday lives of Americans. Please welcome Her Honor, LaDoris Hazard Cordell.
Thank you, Junior.
Welcome, Cordell.
Thank you so much. Thank you, Junior. Thank you, Father John. And Riley, thank you for working with me on the technology here. And thank you for showing the first image. So I greatly appreciate the work of Catholic Charities, and I thank you all for joining us on this brown bag lunch. In June 2019, I began writing Her Honor about my nearly 2 decades on the bench here in Santa Clara County. This book is part primer about the world of state court trial judges, and it's part memoir about my nearly 20 years on the bench. So I call it a combination of the two, primer, memoir, grimoire, a whole new genre. The one and only silver lining for me about the pandemic was that it forced me to stay home and to write. There was nothing else to do. But there would have been no book but for my parents, who saved the letters that I wrote to them about my cases. Next image. Next image. So after during my last 7 years when I was on the bench, every Friday afternoon in my chambers, I sat down and I wrote letters to my parents. And I wrote about everything that happened during that week. The cases I handled, the names of the people in the cases, the decisions I made, and also how I felt about what it was I was doing. So these were very personal letters. And after I retired, I visited my parents back on the East Coast, and my mother, who was a very organized person, pulls this box out of our middle room closet, and she said, "What do you want me to do with these?" Unbeknownst to me, my mother had saved every one of those letters. I hadn't made any copies, and these weren't emails. These were real letters, with postage stamp on the envelope. So I packed those letters up and mailed them back here to me in California, and then it took me a few years before I could bring myself to read the letters. And it was really those letters that gave me the idea that maybe I should write a book about my experience on the bench. Without those letters, I would never have recalled the stories that are in the book. And this is some of what I wrote about my parents. It's just a short passage here from chapter 1 of the book, and the chapter is called Bitten by the Judge Bug. Lewis and Clara Hazard had worked hard to provide for us and to ensure that my 2 sisters and I went to college. Their mothers, my grandmothers, had been the help, domestic workers who toiled for next to nothing, serving wealthy white families who resided in Philadelphia's prestigious main-line suburbs. When my mother, a high school graduate, and my father, a graduate of North Carolina Agricultural and Technical College, married in 1943, they had neither an inheritance nor a nest egg to get them started. What they did inherit, though, was a terrific work ethic and a powerful drive to succeed. My parents would come to own a home and operate Spring Cleaners, a dry cleaning business that supported our family for 40 years. And that's why I have dedicated this book to the memory of my parents. So I completed the book in July 2020 and was published a few months later in October. Next image. I was appointed to the bench in 1982 by then Governor Jerry Brown, making me, as Junier noted, the first African-American female judge in all of Northern California. Next image. And here I am in 1982 being sworn in by Felton Henderson, who is my dear friend, a federal judge who recently took senior status, which means kind of semi-retirement in the federal bench, and he continues to be my friend and mentor to this day. In the previous slide, I forgot to mention those were my parents there and my 2 daughters. I don't know if Riley, you can go back to that one. I just want to show, thank you, Riley. No, just the next one. There you go. So there's my parents that came out to California. This was when I was sworn in 1982, and my 2 daughters, and the one that's the older one standing, she's now a lawyer. They're both are in their 40s right now, and is my ex-husband now. Okay, we'll go forward 2 slides. No, that's fine. That's fine. The world of a trial court judge is one big drama, which is why the fact that I majored in theater in college was the best preparation I could have had for being a litigator, and even better for preparation for a judgeship, where in the courtroom, anything can happen, and where I am the producer director. I tell people when they can stand up, sit down, and when they can shut up, and when they can speak. And anything goes in the courtroom. People lose their inhibitions, and then hold on to your hats. You never know what's going to happen. So in the book, there are lots of war stories from the variety of cases over which I presided. And one of them is this, that's on you're seeing now. It's the name of a chapter in my book, Where There's a Will, and it's about probate court. And probate court is about people fighting over dead people's stuff. That's kind of generally what probate court's about. And in the chapter, one of the stories I tell is about this wealthy inventor, a Stanford Business School graduate who left his entire estate to Tom, Dick, Mary, and Kim. They have no last names. Next image. They have no last names because they are 4 feral cats. I kid you not. And this is from the book. The Walton Trust provided that $600,000 was to be used to maintain the cats in a, quote, most pleasant manner and pleasing atmosphere that as I have been accustomed to give them during my lifetime. What lawyer came up with that wording? I wondered. The trust also bequeathed $3 million in real estate to 7 animal charities. The 3 lawyers who represented the 7 animal charities contended that the trustee had improperly used the trust assets to pad his own pockets. Preferring mediation to litigation, I spent several hours in discussions with the attorneys and worked out a settlement. And most important, I ordered that Tom, Dick, Mary, and Kim should continue to live in the comfort and care to which they had grown accustomed. So in my talking to you today, I'm trying to give you all a sense about what trial judges do in the different kinds of cases they preside over. So this is kind of a journey in my legal world. Next image. I have a chapter in the book called Bad Judges, where I profile some really bad actors in black robes from around the country. And yes, I included myself in this chapter because some cartoons that I had drawn didn't sit well with a few of my colleagues. Now, these cartoons I donated to an organization, a nonprofit called Legal Advocates for Children and Youth. LACY is the acronym, a nonprofit. And LACY provided legal representation for kids. LACY published the cartoons in calendars and then sold them to raise money to provide legal representation to young people. So this is from the chapter Bad Judges about the cartoons. And then I'm going to show you the cartoons in just a moment. So from the book, the drawings depicted judges, lawyers, jurors, and me in humorous situations that illustrated common legal terms. In the first 3 months of 1999, calendar sales generated more than $9,000 for LACY. In June, however, I received a letter from the Commission on Judicial Performance informing me that an anonymous complaint had been filed against me, alleging that my cartoons, and I quote, impugned the integrity, impartiality, diligence, sobriety, and competency of the judges depicted, potentially eroding public confidence and respect. Well, so never mind the long and revered tradition of parody and satire of our legal system by such famous cartoonists as Charles Bragg in this country and Francis Daumier, and never mind the protections of the First Amendment. So what was all this fuss about? Next image. Okay, so this is one of the cartoons that got me into trouble. This complaint was filed. So the idea is it's a cartoon and you try to guess what the legal term is. So you have a judge here, he's smiling, he's in his chambers, and he's holding a bottle of Johnny Walker Red. So what is the legal term? The legal term is take the fifth. Get it? Fifth, right? Okay, so you get what's happening. So let's look at another one, another cartoon. Next image. All right, so this looks like a parody of Newt Gingrich, because it is. And he's holding something in his hand. And you all can kind of guess he's holding a cross. So think of a legal term that has cross in it, and it's cross-examination. Got it? Okay. And let's do one more. So this is a little trickier. Now, in this cartoon that I drew, I drew myself. I'm sitting at the bench and I'm waving my arms. They're just going back and forth, kind of weird. And then there are other people in the courtroom that are doing weird things with their arms in their hands, right? You can see them all, the bailiff and other people, right? So the legal term is make a motion. Okay, you got it. All right, so as for what happened to me when this complaint was filed, and by the way, it wasn't anonymous. I knew full well it was from some judges who just didn't have a sense of humor, whatever. So what happened to me? And this was serious business because the Commission on Judicial Performance has the power to recommend removal of a judge. So it can suspend a judge, it can reprimand, do all kinds of things. So what happened to me, I'm going to let that be a teaser. So if you haven't read the book, you'll find out what happened to me. And let's just say it was not what you might expect. Okay, next image. So I'm going to take you to another part of our legal system that really should hit home with, I hope, many of you. And this chapter in the book is called Thank You for Your Service, and it's focused on juries. The right to a jury trial is enshrined in 3 places in the United States Constitution. It's in Article 3. It's the 6th Amendment, speedy trial in criminal cases, which is mandatory for all the states. And it's in the 7th Amendment, which says civil trials can have juries, and it's optional for the states, although all the states now make it mandatory. Next image. I loved jury trials because I'm a people person. And I saw these trials as ways to introduce people to our legal system and hope that jurors would have a good experience and then feel good about our legal system. Next image. Jury selection, I found fascinating, amusing, and annoying when people who saw jury service akin to the plague did their best to get out of jury duty. And I'm curious, and maybe you all can somehow, even in the chat, whatever, how many of you have ever served on a jury, be it a criminal case or civil case? I have never served on a jury. I would love to. And I just think it is the highest of civic duties that we can perform in a legal system. And I hope that those of you who have served on juries found it to be a positive experience. However, I can understand why many might avoid jury duty. And there's a couple of reasons. There's the time wasted just sitting around for hours, not knowing what's going on up in the courtroom, and very rarely having judges explain, here's why you've had to sit all day. And then there's the compensation or lack thereof. And this is from a chapter in my book from Thank You for Your Service. Juror fees range from a high of $50 per day, Arkansas, North and South Dakota, and in federal trials, to $5 a day, New Jersey and Kentucky, to nothing a day, Delaware and South Carolina, and everything in between. California is near the bottom, coming in at just $15 per day. When full-time employees are called for jury duty, only 8 states and the District of Columbia require employers to pay their regular wages during jury service. So I propose in the book, and there's a chapter toward the end of the book called The Fix, where I propose remedies for these things. I propose that states establish jury compensation funds to adequately pay jurors, and that large employers be required to continue to pay their employees who serve on juries. And almost all big companies do not do that. And I think that California should take the lead. And if there are smaller companies where they cannot afford to pay the salary of their workers who are doing jury service, that's when the jury compensation fund comes in. In my view, when California pays jurors just $15 a day, which, by the way, doesn't count on the first day. You don't get paid all day for the first day. It starts on the second day. What we're saying is jurors don't matter, and indeed, jurors do matter. And this is something we can all push our legislators on to ensure that jurors are paid decent compensation during the time they're on juries. And here's the downside. The downside is that when I presided over juries, I very rarely had people of color sitting on my juries. Why? Because folks who have low income or people who have jobs where they can't afford to just sit on a jury box all day, they have to make a living, so they get excused. So who is left? Generally retirees, and the great majority of them were white. And I think that because we're not adequately compensating jurors, we're ending up with really not having jurors of our peers. We should have a representation of the community, and we're not getting that on our juries. And one way to solve that problem is to see that jurors are compensated adequately. Okay, so next image. let's talk judicial elections. I have a chapter in the book called Judges for Sale. And I let readers know that judicial elections were first instituted in the late 1770s and the early 1800s, when the territory of Vermont and the states of Georgia and Indiana used these elections, to fill seats on their lower courts. In 1832, Mississippi became the first state to adopt judicial elections for all of its judges, from the lowest court up to their state Supreme Court. In the rest of the states at that time, governors appointed judges to lifetime terms during good behavior. Now, I was able to secure a seat on the Superior Court as a result of a county-wide election in 1988. Next image. Next image. And what I did was campaign, because this was an election. So this is a copy, this is the image of the brochure that I mailed out to voters throughout the county. And as you'll see there in the image, I won with 62% of the vote. And my opponent was a white male prosecutor who really came at me, who really attacked me. And next image. And so here I am. So I ran for the seat in 1988, and I ended up being sworn in here, and the presiding judge was Judge Peter Stone. And in between the two of us, you can see there's my mom and my younger daughter, who was just an infant in the first time in 1982 when I was sworn in, and there she is there. So in Judges for Sale, I describe my election experience, one that, quite frankly, even though I won, I wouldn't wish on my worst enemy. And why? Well, first of all, it takes a lot of money to run for a judgeship. And so this is back in the day, 1988, I raised $70,000, and that's about $150,000 in today's dollars, mostly from lawyers, some of whom appeared in my court. That's a problem. I think that's an issue. But that money that I raised, the $70,000 then, that's a pittance compared to today's judicial elections. I'm going to read you just a short passage from the book about judicial elections and about the money. Today, outside special interest groups pour money into contested judicial elections, particularly when state Supreme Court seats are at stake. And according to the Brennan Center for Justice, 1/3 of all elected justices currently sitting on the bench have run in at least $1 million race. During the 2015-16 Supreme Court election cycle, and again, these are state Supreme Courts, political action committees, social welfare organizations, and other non-party groups engaged in a record $27.8 million outside spending spree, making up an unprecedented 40% of overall Supreme Court election spending. Unsurprisingly, 56% of that money was contributed by lawyers, lobbyists, and corporate interests. But there's more. As the influence of money in judicial races grows, so does its impact on judicial decision-making. And this is a huge problem. Once again, from the book. According to the Brennan Center for Justice, they analyzed 15 years of television advertising data for state Supreme Court elections to gauge the television ads' impact on judicial decision-making in criminal cases. Generally, the ads attacked judges for being soft on crime or praised them as tough on crime. 3 key findings. 1, the more frequently ads aired during an election, the less likely state Supreme Court justices were to rule in favor of criminal defendants. 2, closer to their re-elections, trial judges in Pennsylvania and Washington sentenced defendants convicted of serious felonies to longer sentences than normally imposed for those crimes. And 3, trial judges in Alabama imposed death sentences more often in election years, sometimes overriding life sentence verdicts handed down by juries. Judges are not politicians. So politicians make promises to voters to appeal to whatever it is that their constituents want, and that's what politicians do. But unlike politicians, judges are independent. The only promise that a judge can ever make is to adhere to the rule of law, to legal principles, and to constitutional precedent. Judges are held accountable in other kinds of ways by appellate courts who review their rulings and their decisions, by disciplinary commissions, and by properly run recall elections. So it's my view that judicial elections, even though I won mine, they should be abolished. They should be replaced with independent nominating commissions that are bipartisan, appointed by diverse stakeholders. They include non-lawyers and have clear criteria for vetting the candidates. And I believe that this nominating process, either if judges want to be reelected or retained, or new people want to run for a seat, that nominating process should be open and it should be transparent with publicly available data about the diversity of applicants and nominees. And I think until we rid ourselves of judicial elections, and I think it's a long shot, I don't think that the political will is there yet. Until that happens, then we need to do a better job of educating voters about judicial elections. I can't tell you how many times I have gotten late night phone calls from neighbors asking me who they should vote for in judicial races. They have no idea who these people are. We need meaningful voter guides that include detailed profiles of the judicial candidates, including any results of evaluations by lawyers that are occasionally conducted by the courts. Now, you will see in this image here, right? I'm being sworn in and it says 1989, and this happened January 89. However, I was elected to that open seat, it was a vacant seat, in June 1988. So why did I have to wait 6 months before I could be sworn in with an empty seat there? That's a teaser. You'll find the answer in the chapter. Let me say, you will be surprised, and it involved a governor. Next image. Okay, so this chapter is called J'accuse, Judges Under Attack. And this is how I begin the chapter. There is frequently no warning or signal that a judge's decision is destined to blow up in her face. It could be her umpteenth sentencing decision in her umpteenth criminal case. But for whatever reason, one decision takes on a life of its own with disastrous consequences. That's what happened to Santa Clara County Superior Court Judge Aaron Persky. Now, some of you may remember this. In 2016, Judge Persky presided over the criminal trial of a 19-year-old Stanford freshman who was charged with sexual assault of a 22-year-old woman, a college graduate. Both were at a fraternity party at Stanford, and both were highly intoxicated. A jury convicted the student, who, before he was even charged with a crime, had been expelled from Stanford. After Judge Persky sentenced the student to 6 months in jail, the recommended sentence by the probation department, all hell broke loose. Next image. He became the target of a recall campaign coordinated by a female Stanford law professor who has never passed a bar exam to this day. She's never represented a client. She has no background or experience whatsoever in criminal law. And she was outraged that the judge had not imposed a harsher period of incarceration. Now, what the recall deliberately ignored in their campaign was that the punishment handed down by Judge Persky also included ordering this 19-year-old to register as a sex offender for the rest of his life. Next image. Before the recall campaign was over, the name Persky would become infamous throughout the country and beyond. And I want you to look at this image, because if you don't know anything other than the words there, you'd be outraged, right? Judge Aaron Persky sentenced Robert Chain, that's a picture of Mr. Chain, to only 4 days in jail for felony child pornography. I would be appalled if that's the truth, but it is not. And again, this was run by the recall campaign. The truth is that it was the prosecutor, the district attorney, who asked for that sentence of 4 days, who entered into a plea bargain with the defense attorney and said, and this is the prosecutor to Judge Persky, we've all agreed that 4 days is sufficient for this defendant. Does it say that anywhere in the recall information and campaigning? No, not at all. Next image. I became a spokesperson on Judge Persky's behalf in opposing the recall. Next image. And I did this because the recall, it lied about the judge's track record because the sentence he imposed was within his discretion and entirely lawful. May have been controversial, but it was lawful. And because the judge was not legally permitted to speak about the case. And most importantly, because the recall posed a threat to judicial independence. Next image. Judge Persky was recalled after a multi-million-dollar campaign against him. All of this outside money, not from within, almost all of it outside of Santa Clara County. Judicial independence. These two words have never been more misunderstood, distorted, and anathema to so many. Yet judicial independence is critical to maintaining our democracy. Next image. Judicial independence was recognized as far back as in the Declaration of Independence, when the Continental Congress penned its 27 grievances against King George III. And one of the grievances was, he has made judges dependent on his will alone for the tenure of their offices and amount and payment of their salaries. So what are we to do? Next image. How do we ensure that our state court judges maintain their independence? This is a serious issue because when we lose our independent judiciary, we lose our already fragile democracy. The answer that I propose in the chapter in my book called The Fix is not to abolish judicial recalls. No, it is to strictly limit judicial recalls to instances of judicial malfeasance or failure to perform duties of the office, or to judges who've been convicted of serious crimes. Next issue. Next image. That is the way it is done in Georgia and Montana. Recalls in these two states can never be based on a judge's lawful decision, no matter how controversial. And in my view, that's how it should be done in California. Next image. The recall provision in the California Constitution is just one sentence, right? It is. Recall is the power of electors to remove elective officers. Next image. Okay. I propose in the fix that that provision be amended to resemble the recall laws in Georgia and Montana. So the revision of California's recall system would require an amendment to the California Constitution. And I've left the first part of it absolutely intact, and then added that recall of judges, okay? Recall of judges, there'd be these three criteria. Now, if our legislators won't take the lead in amending this provision in the Constitution, I think that we, the people, the voters, and especially those people in the legal world, should use your influence to make this happen. And if you think, oh, amending the Constitution, that's a big deal. Well, it is a big deal, but it's been done more than 200 times. The California Constitution has been amended at least 200 times. So it's absolutely doable. And my concern, if you're still not kind of getting where I'm coming from, is that picture yourself in a courtroom and you've presented, your side has presented evidence, and the judge is ready to rule. And the judge stops and thinks for a moment, and the thought bubble says, I know what the right thing to do is, but if I do this, it's bound to get some people upset. So if people get really upset, then they might try to recall me. So I don't think I can really make the decision that's the right decision. Maybe I should do what they want. We don't want judges putting their fingers to the political wind in order to make decisions. We don't want that because that destroys our independent judiciary. So I believe amending the Constitution to say that judges can be recalled, but only when they do things that are blatantly wrong and not because they make a decision that we might not like. Next image. Charles Hamilton Houston was a brilliant lawyer. When he started his law practice in 1924, it was he who pioneered the idea of using the Constitution to promote racial justice. The grandson of slaves, Houston was born in Washington, D.C. in 1895. He went to Amherst College And after serving in the Army, he attended Harvard Law School, becoming the first Black member of the Harvard Law Review. He was a teacher at Howard Law School at Howard, later became the dean of Howard Law School, and one of his students at Howard was Thurgood Marshall. Houston devised, coordinating with others, he devised the long-range strategy that ultimately led the U.S. Supreme Court in Brown versus Board of Education to declare that segregated public education was unconstitutional. Houston died in 1950, 4 years before the Supreme Court decided Brown and made his vision a reality. Next image. Next image. Houston was fond of saying to his Howard Law students, "A lawyer's either a social engineer or a parasite on society." By being social engineers, I think Houston meant that lawyers should always be about the business of making a difference. Not just lawyers, anyone in the legal profession, making a difference, of using their legal acumen to make this world a better and more just place. And that could mean being a public interest lawyer or being a corporate lawyer who takes time to do pro bono work for worthy causes, or being a lawyer in private practice who volunteers in the community. Or I think it could mean a retired judge who uses her time to make the criminal legal system more just. And you notice I don't call it a criminal justice system. We're not there yet. It's a work in progress. Next image. The final chapter of my book is "In My End is My Beginning." And in that chapter, I tell what I did after I retired to try to make the criminal legal system more just and fair. I'm just going to read you a short passage from it. In 2006, I had written an op-ed against California's draconian 3 strikes law for a local newspaper that came to the attention of Montel Williams, host of a popular national television talk show based in New York City. I accepted his invitation to appear on the show, and in September 2006, I went there and talked about my view of the law. The other guests on his show were 2 Black women whose sister, Kelly Turner, was in her 11th year of a life sentence for a 3rd strike, possession of a stolen check, and the amount of $144. When I returned to California and to my job as a vice provost at Stanford University, I couldn't get Kelly's situation out of my head. The injustice of Kelly's life sentence for a $144 3rd strike was exactly why I was so opposed to the 3 strikes law. I objected to the law when I was on the bench, but other than trying to soften its blow at sentencing hearings, I hadn't been able to make any meaningful change to it. Now, as a private citizen and no longer muzzled by judicial canons, here was an opportunity for me to do more than write an op-ed. If I couldn't change the law from the inside, I could fight back by getting someone out from under it on the outside. I had no idea that this fight would go on for more than 2 years. Well, I ended up I found a lawyer, a corporate lawyer, who decided to help me pro bono in filing what's called a habeas petition seeking Kelly's release. We ended up filing this. It took 2 years, more than 2 years, for us to do all the work required to file this petition. I enlisted the help of other experts, all pro bono. And so we filed it. And then this other attorney, whose name is Roy Bartlett, we flew to Los Angeles because Kelly had been sentenced out of Superior Court in Los Angeles, and for the hearing on this petition. And that was only the 2nd time that I met Kelly. I met her once when I drove to the prison to meet her after the Montel Williams show, and then for 2.5 years worked trying to get her release. So next image. This is Kelly sitting there in her jail blues, and sitting next to her is the prosecutor who, when we got to the hearing, did not oppose our habeas petition, and there I am standing with Kelly. Next image. And now there's Kelly with Roy Bartlett, and you can see Kelly has the handcuffs on. They wouldn't even take the handcuffs off just during the hearing. And I was sitting next to her at the counsel table. And next image. And there, sitting in the courtroom, were her two sisters. They're kind of in the middle, and other friends and family members of Kelly. Again, she'd been in prison for, at this point, it would have been 14 years. She was into her 14th year. Now, the judge ended up granting our petition and told Kelly she was free, and she was released from jail the next day. Again, 14 years into a life sentence. And I want you to see what freedom looks like a year after Kelly was released. Next image. There she is, right in the middle with her two sisters. This is 1 year after serving a life sentence and 14 years for a $144 stolen check. In closing, and let's leave that image up there right now, because it's such a good image. It always makes me feel good. And by the way, Kelly is doing great. She got married, she got a passport, she's been to Italy. She's actually gotten awards from the state probation department for her work with kids. Just doing great. So in closing, I want you to understand that I believe there's much that is good about our legal system. The very principles that are the foundation of the system and our nation are the best in the world, that all are created equal, entitled to life, liberty, and the pursuit of happiness. We have the right to speedy trial, a right to trial by jury, right against self-incrimination, right to due process. The problem is in the implementation. The property white men who established these principles, many of whom owned people who looked like me, did not contemplate that these principles would apply to women, to poor people, and to people of color. So the challenge for all of us, you, Catholic Charities, for all of us, is to ensure that these wonderful principles that underlie our legal system are applied equally and fairly to all. Next image. So I leave you with a final passage from my book. Okay, and the final passage. Judging has been the most fulfilling of my various careers. For nearly 20 years, I wielded power over the lives of thousands of people. And for nearly 20 years, I did what I believed to be right. While it is up to the next generation of voters, politicians, activists, lawyers, law professors, and judges to continue to clear the path to a more perfect union, I refuse to give up on our legal system, and I will never give up on our judiciary. Hopefully, neither will you. Thank you all so much.
Thank you, Your Honor, for this magnificent presentation.
That was fun. Thank you.
Yes, I read the book and I continue to go back and read passages of it. We don't have any questions in the chat. We have some interesting comments, but please put your questions into the chat so that you can ask Judge Cordell any question that you like.
Well, comments are good too. Comments are good.
Well, I'm going to share some of the comments as
right.
well. You asked about serving on a jury, and one person said no, they've never served. They've called up, but they've never were allowed to serve. And then one said that they had actually wanted to serve and then been called twice, but that didn't sort of materialize. And one stated that it was frustrating because seemingly the jury was swayed by the appearance of the plaintiff and not by the actual facts that were presented. Another person actually said that they had they worked, the company they worked for gave a stipend to the persons that served on a jury when they worked the day shift, and she was a worker at the night shift, so she was not called on. And she said, and later, a few years later, when she was called upon, she lived in San Jose, but she was to go to Palo Alto to the courts, and she said it presented a challenge for her because she didn't have actually reliable transportation.
These are all the problems. These are exactly the issues that come up in dealing with jury service. And if people were adequately compensated, we need to pay more attention. Our system really depends upon the integrity of a jury that is representational of the community. And right now, I think in most states, it just doesn't happen. So this is something that we might consider undertaking.
I have a question here. It says, can you comment on the politicization of the SCOTUS confirmation process and how this has been used to attack SCOTUS and the federal judges like Judge Cannon?
No, to stack SCOTUS.
Yes, I understand. So, so this question pertains to our federal judiciary. So federal judges never have to worry about putting their fingers to the political wind because they are appointed for life. They don't ever have to stand for election, ever. It is lifetime. The only time a judge gets removed is through an impeachment process, which involves the House and the Senate, and it has very, very, very rarely occurred. So what we have today, again, my view only, is a Supreme Court that is entirely politicized and weaponized. There are 6 justices on this court now that have, for example, in Roe v. Wade, and again, I'm not trying to get into whether or not you support Roe v. Wade or not, but my point is that there was legal precedent, and these 6, I call them the Gang of 6, decided to ignore legal precedent and do what they wanted. Why? Because they could. If there are 6 people there, they can do whatever they want. And I'm concerned that this is what is going to happen next. They are going to hear a case next month regarding the lifeblood of affirmative action. So the plaintiffs in the case is an Asian American group funded by a rich white guy who wants to get rid of affirmative action. And he has actually been very effective as he's been funding groups and organizations and individuals to get rid of affirmative action. So now the Supreme Court is going to hear it, and they're going to make a decision as to whether or not race can ever be considered in admissions with regard to colleges and universities. And given the history of this court and the Gang of 6, it's likely that just like with voting, the Voting Rights Act, which was gutted by a conservative majority in the Supreme Court, I believe affirmative action is in danger of now having the race as a factor being totally taken out. And when that happens, I just already am upset, and I'm hoping that I'm wrong. But my prediction is the Gang of 6 are going to do their thing again. It is now a court that has been weaponized and politicized. And the question I always wrestle with, well, what can we do about it? What can we do? They are appointed for life, and some of them are young. So what can we do now? Probably nothing. They're there. And what we have to do is make sure that people vote, because if you get the right people, and I say right, meaning people who understand that Supreme Court should not be weaponized, get them in the Senate, then when it comes time and a vacancy comes up, you'll have the votes to put someone in who will be fair to both sides and not come in with an agenda. So I'm very concerned about it. I'm very disheartened. There are people now advocating that the whole system for the Supreme Court should change, that we need maybe as many as 40 or 50 justices on a rotating panel that address issues that come up in geographical areas in the country. So if you had a panel of, I don't know, 7 justices who would come up with an issue dealing with area, say on the East Coast, and say a geographical issue came up on the West Coast. So there are scholars now writing about this, saying that we need to just flip this on its head and try something different, because what we have, and really have had even before this, is a very political process. And the idea is, how can we get away from that? So I am now just reading about these options that people are proposing, but I believe we absolutely need to change how the Supreme Court is selected. And also, I don't think they should have lifelong tenure at all. I believe there should be term limits. Off they go. And that's just one of the things that I think has to happen. If you give lifelong tenure, they're not accountable to anybody. They can do what they want. And we're seeing the effects of it right now. I probably went on too long, but anyway, I get very concerned and, as you can tell, very intense about this issue.
Thank you. We have another question here. What actions do you recommend to take in reducing the feeling of helplessness in light of the recent support court rulings?
Well, first of all, we are not helpless. So let's get that off the table. There's no such thing. We are the people. We are the voters. We are not helpless. We can determine what happens. What infuriates me is that there are so many people who don't vote, who just don't vote. It's not that they're not qualified, they don't vote. And in California, it couldn't be easier. You don't even have to put a stamp on the ballot. Everybody gets a ballot, but people don't vote. So why don't they vote? One, some people are just lazy. Some people feel, well, the system doesn't care about me. I don't care about it. So why should I vote? Well, they pay the price when they have legislators who are doing things that mess up their lives. And then there are others who just feel like, I don't have a stake in anything anymore because I'm feeling like, who cares about me? I can hardly pay my bills. The gas prices are going up. And I get that. But the remedy is not to not vote, because that means you're complicit. You're enabling the system that you don't really like to continue. So all I can say is that the voting would change everything. If poor people, if people of color, if women, if people just went to the polls, we could have a country that we could just turn all of this stuff around. Right now, I am terrified. I am terrified about what could happen to our democracy because it's just so fragile. And for years, I'll admit it, I took our democracy for granted. We always have it. Well, we don't. So I'm concerned, my view right now is really concerned about our judiciary. With our Supreme Court, and again, I just don't say Supreme Court, with the Gang of Six doing their thing, we have to end up relying on our state courts to keep us from this democracy falling apart. So with regard to Roe v. Wade, the states now, that's what the court said. The court has said, the six said, oh, let each state decide what they want to do. All right, so here we are. Fortunately, we're in California. Again, I don't want to put my views on anybody else, but I support Roe v. Wade. And we have right now a legislature that is in sync with that, but there are many states that are not, and we have to turn again to our state courts. And that can make the difference. These judges can make the difference in making sure our democracy continues. And that brings up, of course, well, who's on the courts? Who are we electing? How are they getting there? And so much of our courts are politicized. It's all about money, special interest groups. And when you read the chapter in my book about judges for sale, it's shocking. It's just horrible what's happening around the country. And only we, the people, can change that. So the only way to change it is to become educated, understand it, become aware of how it works. Then you can generate policy and make changes to make the system more fair and just.
As we generally, we always almost run out of time, so we have a couple more.
No, we can't.
No. One person says, she's heard that people don't register to vote because they don't want to serve on a jury. Can you give us a short piece on that?
Sure.
Judge?
So again, read the chapter. Thank you for your service. It explains how jurors are selected. It isn't just from the voter rolls. DMV and California has added some other criteria. I can't remember now, but I mentioned it in the book. So it isn't just voting. If you don't register to vote, you can still be called for jury duty. That's not the issue. And my point is, yes, serve on juries. And, we need to make our changes to it, but think of people who are on trial and they want people on a jury that at least look like them. And that's important. That's important in terms of getting trust in our legal system.
There's a term limits for senators too. Do you think that we can legislate for affirmative action?
Well, if the court says affirmative action, you can't consider race, that's going to be the law of the land. So, and this is regard to admissions, so college and university admissions. So I'm not sure exactly what steps are going to be taken, because once the court rules, if a university decides to make race a factor and the court says, nope, you can't do it at all. You can look at socioeconomic background. But some schools are doing that, and they're still losing the representational diversity in their student body. And it's just amazing to me. This whole country was founded, created, built by mostly people of color, the Chinese who were enslaved, who built the railroads, and Black folks who built just about everything else in this country. And yet we can't mention it or talk about it in admissions. It's totally bizarre. It's just bizarre. But that's where it appears the Gang of Six might be headed. So, but my point is, don't give up. Are you kidding? This is when we step up more than ever. This is when we step up. So anyway, I just hope that everybody will, one, read the book. If you're interested in changing our legal system, you have to understand it before you can change it. And once that happens, I hope you'll then have the incentive to work together. Groups can do more than one individual. So remember, people united can never be defeated. So I'm hoping Catholic Charities might get behind some of these suggestions I'm making in the book to make our legal system more fair and just.
Thank you, Judge Cordell. I don't see any more questions in the chat room. I would like
This
to.
person has a hand raised. Mary Jane has her hand raised.
Mary Jane, thank you, Mary Jane.
I know we're almost out of time, and maybe I missed that, but so your feeling is on judges, like, because I really try to be informed, but I just do find those like, it just seems a lot to really know all the judges. There's a whole other thing with referendums, but you think that judges should be elected by the public, but we just need to be more informed about it? Or do you have thought, you would rather California judges are appointed and not elected?
No, I think there should be a merit nominating commission made up of people like you and lawyers and judges, this is all public, and who vet people who either running for re-election. This is until we get rid of elections. Okay, so today in California, there is such a commission. It's called a JNE commission, J-N-E, Judicial Nominations and Evaluations Commission. All their work is done in secret. And they rate people who want to be judges, however, the governor is not obligated to go along with whatever they recommend. The governor can go rogue and nominate whoever the governor wants. What I'm recommending, and you can read that in the book, is that there be these nominated commissions, no more judicial elections at all. These be very public, and that the public, if you've been in court before a judge who wants re-election, and you know this judge was rude or has a issue dealing with women, you have every right then to be heard, to weigh in on this. And this nominating commission would then make recommendations and might recommend 3 people for 1 seat on the bench, and then the governor can choose one of them.
Okay.
But they come out of the
election.
We're about to run really out of time, unfortunately. Thank you all for your participation. Father John, are you there?
I am here, and I just want to thank Judge Cordell for her generous time and wisdom and insight, and thank all the participants who are part of this. We'll be posting this up on our website, I believe, fairly soon. But on behalf of the agency, thank you very much, Judge Cordell, for sharing this amazing wisdom you have with all of us, and thank you, Junier, for your work. What do we have for next month?
Oh, next month we will have a panel discussing the issues concerning African Americans during the election time.
Okay,
and that's I believe October. Yeah.
Before we go, I just have one final thing, and activism is my rent for living on this planet. And for those of you who agree with that concept, I encourage you all to always, every day, find some way to pay your rent. Thank you all so much.
Thank you so much on that word. Thank you.
Thank you. Thank you.
Bye-bye.
See you all next month. And thanks again, John and Judge Cordell. Bye, everybody.